It was nice.
Yeah, I know it was.
But I guess if our line.
I'm sitting there looking at the picture.
Hey, so how everybody doing today?
Good, how are you?
Awesome, awesome.
recording, but not live streaming, so that's.
Oh, it's recorded.
Okay, so we are
good.
recording but not live stream. Okay, everybody ready to get going?
Yeah.
I don't have my script, Roseanne, because I don't have Wi-Fi. So, but we are meeting in work session on this day of August 23rd. Is there anything else I need to say?
No, you're not being live.
Yeah, Roseanne wouldn't have called me. I probably wouldn't have been here. I was
So
knocked
the meeting's
out.
being recorded. And tonight we have our annual training on public meetings, ethics, and public records. Mike Porter from Bill and Ash is here to walk us through this training.
Thank you. Thanks for having me. It's nice to be back. A couple live groups again, so I'm getting to enjoy that. And I was welcomed to the meeting by Director Constam, who pointed out that this was the 6th time she's been in this, and not at 7th, 6 in the past. And that's one of the benefits that you have of being on the board of directors is annual training. I really just wanted to use that as a segue to say I appreciate that there are a number of people who get this every year. And I was thinking this afternoon about certain trainings that I have to go to every year. And when I put my attitude a certain way, I say, well, maybe I'll hear something that makes me think a new way about something or just a reminder. And it is a good practice to just have these things that help you issue spot as you go through the year so you know when to invoke the staff's assistance that deals with the nitty-gritty and the details. So at any rate, it's a little naturally different this year because Randy Geller was here last summer. And so by just naturally, he and I will have a little different perspectives or things that come to mind as examples. And we do plan to cover public meetings, the big picture issues for the board, a little bit on public records. A lot of that is very administrative, but there are certain points that I think are helpful for board members to be thinking about. And then Oregon ethics law and some of the key prohibitions in the code of ethics. So I like to start and have done so in each time of the 6 that I've participated with the policy of these laws, because the policy really is something that can be a fallback for trying to sort out some of the challenging situations. I was just speaking with one of my partners, Jeff Condit, today about how we were unhappy about the way the legislature worded something in these statutes. And that means there's going to be ambiguity between statutes and the regulations. And so, what is the policy? Public be aware of the deliberations and decisions of governing bodies and the information upon which decisions are made. And laws, decisions of public bodies should be arrived at openly. So sometimes there is a nuanced area and you get a decision tree. Can we take a hyper-technical reading of this and maybe go into an executive session? There may be factors that say, yes, we need to do that. But there may also be, hey, this is a close call. Spirit of the law is to be open and transparent. And anytime you do something that is not perceived to be transparent, even if it's legal, you're running the risk that you're not perceived to be open. So a lot of times when Liz and I talk about these things, or Kate and I talk about these things, and it's tough. Okay, well, let's keep that policy in mind as we're thinking through how do we sort out the challenge. So the slides you have, this is hyperlinked, but if you just fall in love with the topic tonight or one of the times that you're working on public meetings or records, the Attorney General publishes a public records and meetings manual. When it's printed, it's about 1.5 inches thick of small type. It's really kind of the Bible for this type of problem solving. And so it's available to the public through a website, and you can just click on that if you have questions. We'll talk about some of the nuanced areas is where we'll focus. Those are what bodies are subject to the law, when is it that we're actually meeting, what happens when things go wrong. Oh, I think that must have been where my mouse was, and some of the challenges that board decision-making runs into with respect to executive sessions. So we'll talk about what a public body is, but sometimes I realize that kind of gets right into the weeds a little bit without just what the general rule is. The general rule is for a public body that all meetings are open, and now a public body has to provide, to the extent reasonably possible, the ability to participate electronically. And we did not schedule or plan the Wi-Fi being down tonight, but there were more than reasonable efforts to make this available electronically, plus a recording is going to be available electronically. And that gets into, well, what is reasonable? I will point out that as a large district is the largest district, what's reasonable for Portland Public Schools, if you go out to Eastern Oregon, it's probably a different standard. Although I will say some of those districts have been doing things remotely, for a lot longer than anyone else because of their location. But the circumstances matter. I think you should presume, or the district should presume, it would be held to a pretty high standard for what someone would expect is reasonably available to the public. So, applies to public bodies. A public body is, all the definitions in these laws are extremely broad. So if you took the wording from the statute, a public body makes a decision and a decision is any determination, any action, any vote, or final disposition. And so the public body is a body with the authority to make decisions for the public body. Easy enough when you're talking about a quorum of the board. What gets sticky and more difficult is when a body has the authority to make recommendations directly to the public body. And so that also is a public body subject to the open meetings laws. And it really prompts the question, if you have committees, is this a committee that is for the board and that's going to report for the board to take some action? If so, most likely going to be a public body, needs to comply with public notice requirements and the public meetings law. You can obviously and do have committees that are for an executive. So the committee reports back to the executive, the staff member, somebody in an administrative role. And the question there will be, that individual should have some discretion with respect to what that person provides to the committee. In other words, I can imagine somebody trying to end run the public meetings rule in some way where it's form over substance, that the person in the administrative position sees themselves as just a rubber stamp. And I think that you start walking into a danger area.
So if they're advising the board and that's the criteria, and they're making recommendations, so does that mean all the issues related to quorum? And this may be also a question for you. So for example, the climate committee that's got 9 people in it, they're advising the board that if they need to know that they're a public body and that 5 of them can't go have beers and
Talk about anything related to their work with PPS climate committee.
do our committees have that sort of training if they are advising the board?
I'm not with systematic training. I think that's comes up on more of an ad hoc basis as these are committees given that authority by PPS, not just any.
I do think there was one training that we did when there was a number of.
But not on a
So broad.
systematic, regular
No,
basis
not
like you.
But so yes, those can end up and are body subjects to the public meetings law. And that was a helpful segue into the next topic about people going out and having discussions. Actually, before that, so to your point, we need to evaluate any advisory committee structure and the purpose and how you really want to operate. That shouldn't be a lightly taken decision because there are consequences to the way a committee is structured and decisions are made. And it leads right into the point of, okay, so when are people meeting? And a few years ago, there was this case, Handy versus Lane County. It was discussed a lot when it came out, and it was about basically where there's an email chain here between board members, email chain over there between board members, and eventually you just put the email together and you say, how is this any different than sitting in the room? And in fact, just in the last, year and a half or 2 years, all the chat function programs, Teams, the Google Chats, all of those things really run the risk of putting a board member into a situation where they're involved in a public meeting and possibly not thinking about the fact that they are. And so, even just looking at this in real time here, avoid reply to all almost seems like the antiquated way of describing this, because it's, watch out for chats, text strings that have multiple board members, or it starts as just 2 people and then it goes to more. You're really running a risk of a public meeting, and it's difficult, but that's just the way the law the law operates. And we're not worried about like some accidental "I want the vegetarian" reply to all. When you're talking about something that is going to be decided on by the board.
A more meaty topic.
Yes.
Oh, that's good, Julia.
I threw that in there, the vegetarian thing, just for the people who've been here 6 times.
Attention.
So beware the accidental quorum. That's really just a broader way to say that. And that can happen. Social events are permitted. Boy, it just seems really difficult to have a social event that isn't perceived as something where business is being conducted. I went to graduate school at the University of South Carolina, and the regents would go to the football games and they would just notice it as a public meeting because, hey, why not? They're not only talking football up there, especially in South Carolina.
Can you talk a little bit of what can be shared though? So I'm pretty familiar with sort of these decisions in serial forms, but it is okay, right, to send out an email, say as chair, that says, here's my recommended version of X.
Yep.
And to the board. And so it's the discussion that's really the problem, right?
That's a great distinction because what the court described was deliberating toward a decision. So I can imagine you could come up with all sorts of hypothetical situations where you could argue that's not what's really going on. So let's say somebody responds and the response is, I don't think we're ready to make this decision yet. And there's a discussion of that, but it's really brief. Maybe I can go in and argue that's really talking about something logistical. But even as I say that, I just recognize the slippery slope, like where do you draw the line? So, obviously electronic communication is part of the world. And then, your conclusion is this will be something we can discuss in our meeting as on the agenda.
I guess what I'm getting at, is there a useful distinction? I mean, I think the reply to all makes a lot of sense. That's obviously a conversation. Is there a useful distinction between putting something out there, which is okay, replying to it or deliberating is not?
Yes,
any
I think
board
putting
member-
something out there is different.
It's not generally part of our culture. Any board member could say, hey, by the way, I'm really excited about this resolution. I plan to support it this week.
Yes.
Send it to the board. And that still is not a violation of public meetings law, right? It would only be if other people say why or
Right.
as well.
I'd say that's not deliberative towards a decision. But you could just imagine how once things get going, they kind of compound themselves and natural responses. So, if you're attuned to it, it's one of those things where when I prepare people to take a deposit, to have their deposition taken, I say, when that voice in your head asks you, should I keep talking? The answer is no. It's, if I should I respond here, I'm going to err on the side of not falling into that trap. Unless you're a really good deponent who I trust entirely to tell our story, which is not common. So basically, you just always need to be aware of this. That's the upshot of the serial communications problem. It has been around, the handy decision has been around long enough that the awareness is certainly better, and I think people are a little more, even if they don't like the concept, you know, even the way you're describing it, they recognize it. I want to point out some of the most common challenges are, when is it permitted? You know, there are statutory exemptions that are in the Oregon Public Meetings Law, and then there are a smattering of statutes that are all over the books that can provide the basis for a public meeting, more specifically. So, for example, school districts with an expulsion hearing, that's an executive session in addition to those that are permitted specifically under the statute. And the big issue is scope. You have to stay within the constraints of the purpose, and I'll have an example here, kind of a life example coming up. I know Liz often, you know, says, I'm going to be the guardrails, and is listening for, hey, are we getting beyond the scope? But sometimes that's a nuanced depending on what the exemption is allowing the executive session. And so really, when in doubt, stop, make sure that you're within the purpose before moving forward is a good practice. This text is small, and I'm sorry, but I can give you a pretty simple rundown of it. The Oregon Ethics Commission enforces the Oregon Open Meetings Act. It had an investigation and a final order this year. It probably has 15 or 20 a year in May, and it was a school district case where executive session was held to consider records exempt from public inspection. There were two types of records that were properly considered. There was confidential medical information about an employment situation, and then there was attorney-client privilege information. As is easy to occur, well, what's the policy behind how we ended up here in this legal employment confidential situation? Well, is that policy the right policy? Should we really be doing that? When's the last time we looked at the policy? Well, that's the decision there was about an employment circumstance, confidential employment circumstance, not about what are we going to do with the policy. And as you know, the media can sit in most of the executive sessions, and this was a complaint brought by the media who, you know, said, geez, that doesn't sound like what I understood this executive session to be for, and, you know, makes the media member look good and fighting for transparency, and makes the district look like it was trying to take advantage. Helpfully, it was a stipulation where they did some training to straighten that out, because most of the time these are tricky areas where there's not intent. And as I mentioned, Oregon Government Ethics Commission enforces it. They can assess a civil penalty for up to $1,000. I should note, it's not on the slide, but if there is a willful violation of the Oregon Open Meetings Law, a board member can be held personally liable for the attorney's fees of the challenger who brought a claim that it was an improper executive session. Willfulness is a hard standard. You wouldn't expect that, but it's something to be aware of. So knowing that we got started a little late, I'll stop for a second, see if there's any questions. I'm going to move to very briefly public records before getting into Oregon Ethics Commission. And I know you've got a 6 o'clock and need some transition.
Questions?
Okay. All right, Oregon Public Records Law. In the times that I have participated in this session, we actually have not had this as any of the slides or particular, it's come up, I'm sure, public records, because there's a relationship with among a lot of these laws. And so I thought, oh, well, I always start with the policy. So let me go get the policy of the public records law. And gosh darn, if the legislature didn't write a policy statement all about the archivist's rules, but not any really good one about public records. And anyway, was the archivist, sometime maybe I'll do a training on the archives rules, but that's one where you will definitely want to have something else to do during that. They are, although really in recent news, the archivist rules suddenly seem a lot more exciting than they did probably last time I presented on it. At any rate, the upshot is every person has the right to inspect any public record of the public body in the state, except as expressly exempted. So, that's easy enough. That is what the general rule of public records law is. Anybody want to guess how many exemptions there are for public records?
5.
5? All right. We got 5. A lot. I should have bought a prize, but then that would be an example in my head. There are 84 exemptions in the public records law. And I don't know about all my legal colleagues, but if it's not an obvious one, a lot of times it's open up the public records manual and go through and see if something else wraps it up. So there are a lot of exemptions. Many of them are very specific to very narrow sets of records, and they don't come up a lot. The key issues for the board are really the breadth of what a public record is. Any writing containing information relating to the conduct of the public's business, regardless of physical form or characteristics. Any writing, just as broad as you can be. So all the chats, all those types of things have the potential to be public records. Interestingly, there is a out for public records for records stored on a private computer if they are not conducting the public's business. So it's really not even a necessary exemption. It almost doesn't even make sense, but it drives home the point that just doing something on a private device does not exempt it from public records. And I had a conversation, this was probably 15 years ago, with a public official who was, had quite a bit of information we knew on a private device. And the public official, I remember asking me, what are you going to do? Put out a warrant. I was very junior then. That kind of scared me, but think about that now, and maybe he'd be more worried about it, he or she.
We had a board member who refused to release Facebook message communication in a public records request, and then took that exemption, that elected official exemption from, I don't know. It was clear the wrong thing to do.
Yeah, I mean, it's ultimately like, can I go get a warrant as the district's counsel? Probably not, but is somebody going to fight you tooth and nail? Yes, so know that you are not protected there. Other issues to be careful about with public records, privileged information is exempt, so attorney-client privilege information.
Nuclear secrets.
What's that?
Nuclear secrets.
Nuclear secrets. We have seen examples where information that is privileged gets disseminated outside of the privileged group. That causes potential significant problems and can subject a board member to personal problems beyond subjecting the district to claims that privilege was waived. So that's definitely an important consideration. Also, having otherwise confidential information in records, just know that they're public records. And if it's not something that, if you think, well, this is confidential, you better be very confident that some like privacy law applies to it, because your presumption should be things are not confidential. And we already described personal. Anything on public records? Anything come to your mind that ought to get tossed in, Paige or Liz?
I think you just want to make sure on personal devices that have public records, you don't delete things.
I have sort of a practical question. So things are public records, but public bodies also get to define their retention schedules in a lot of cases.
Mm-hmm.
What prevents a public body from just saying the retention schedule is 1 day?
So there are some minimum retention schedules that the archivist puts out, and then there are some places where you can have an adjustment to what the schedule is. So it's a very highly regulated area, and you can make some adjustments, but not everything.
But not everything. Do we know, and I'm sort of curious, getting back to like text messages, right, which are clearly public records. What is PPS's retention schedule on tech? Because whereas phone, voicemails are not, which is a weird anachronism in the law, that, you don't have to keep a phone record, a voicemail. If you do have a voicemail, it's a public record that can be discovered, but you can delete it without any penalty. But you can't do that with text messages until when?
Do you know what the
I don't know
retention
off the top of
schedule
my
is?
head. I can follow up. I don't know what it is.
Well,
I'm
that's
just curious.
interesting because phones usually have an auto set of like 1 year.
Well,
And
exactly.
sometimes it's
Well,
not that
it's
it's a
never-
text message, it's the content of the
That's
message that
right.
can trigger a different retention. It's not the form, but the substance.
Excellent point. Right.
Right, and so it's like the type of record. If it's something, in theory, there shouldn't be personnel records that are actually text messages.
But you could have FERPA records.
But you could definitely have FERPA records. Actually, that reminds me of one other hypothetical, or it's not a hypothetical, a colleague ran into twice totally different situations where board members were bringing constituent concerns to administrative staff. But within those concerns they were bringing on behalf of their constituents, they were also describing their own personal experiences. And then a public records request that encompassed those was made, and the public official, elected official said, well, but, paragraph 2, that's all about me, that's not a public record. And, that was something to work through that I would just suggest to, be cognizant. That's a pretty thin reed to stand on, that somehow that's public and not private. And I think somebody would question, well, then why are you using your access to get your own private situation taken care of if you redacted that out or something? So I haven't seen that come up a lot, but colleagues said
If
that.
we're using district devices, we don't even really have to worry about it, because that can be retrieved even without us doing it.
Email can, I actually don't know about.
I think that's the whole purpose of it. Platform. That's what my understanding was from our professional conduct policy. Because the district has access to the text.
I have to go back to 2018, when we heard about what our phones do in that policy, Julie. I don't trust my memory, my technological.
I think it's going to depend on whether the districts install
Right.
software to capture it. So I mean, I think the idea is don't delete anything, even on a school phone.
It makes it
You know,
easier
for
to
sure that-
capture.
Because that software is very new. The software that allows
Yeah.
you to centrally capture and scrub text.
And that's is it remind that we have some other tools that we allow teachers or school staff to use to communicate with students, because all of that is captured. I just don't remember all the text messages. When it's on a district device, it makes it easier in discovery to capture everything instead of having to. But there's other reasons why district phones are easier to just image and retain.
And also know, of course, that all the metadata is discoverable. And so if you delete something trying to make it go away, people, if they are really motivated and have the ability to do, the funds to do so, they can figure that out. So we don't know how that looks if it looks like you're deleting something. So that's good. Public records kind of bleeds into the fact that, like, putting public records aside, you all probably know, and just the reminder that it's all, unless it's privileged, discoverable, and so if some issue comes up and there's litigation, putting public records aside where somebody has to ask for it in litigation, just about anything can come out, and it'll be projected on the screen behind you while you describe what it is that you meant in that whatever communication. So the last segment here, there's not a lot new here, so we'll just get through kind of the reminders here. The Oregon ethics law, obviously, you're in a position of trust, and so have to uphold the principles described in the law, avoiding conflicts of interest, et cetera, ever conscious of the public's trust. And I think in the times we live in, we see how easy it is to have the public lose trust, sometimes unfairly, but don't create situations that create an easy opportunity for losing trust. Like with the Oregon Attorney General Public Records and Meetings Manual, there's a lot of good information on the Oregon Ethics Commission's website. There is a manual for public commission guide, ethics commission guide for public officials. That's a good kind of plain English description of these rules. And then we'll talk about the three primary areas under the code of conduct that come up the most: use of office, gifts, conflicts of interest. And I am watching, knowing we'll need to head out pretty soon. The general rule, I think you've heard it a lot probably. You may not use or attempt to use your position or office to obtain financial gain or avoid financial detriment. So second part, avoid having to pay for something you might otherwise have to. Any person serving as a public body officer, employee, or agent, regardless of whether compensated. There's a definition of relative that gets into steps. Also, spouses, relatives are implicated by many of the rules under the Oregon ethics rules. There are rules if you end up in a conflict situation involving a business with which you or a relative are associated. That falls, or that arises for directors, officers, employees, or agents of a couple of types of corporations, basically publicly held corporations, or that are pretty large or aren't tiny, $100,000 or $1,000 of a privately or closely held company.
Just before you move that slide, is that an and, those last
Or.
two points? It's an or.
Yeah, you are.
So
A business may be, you are associated with a business if it's one of those two, privately held or
But
publicly
you're
held.
associated with it, not just a stock.
Associated with it.
Well, it
I just didn't hear
says,
the last.
Not just a stockholder, you have $100,000. I can't tell because it's a segment fragment.
Sure.
What that
No.
means.
Yes, I'm going to look at the statute right after we finish to make
Okay.
sure I answer you correctly. It's not coming straight. The here's just a kind of a classic example here of something that the Oregon Ethics Commission ended up handling. There was a road district commission, which I didn't know was a thing, but road district commissioner hired a contractor to fix a ditch and construct a culvert. A particular commissioner didn't have to pay for a lot of work that would otherwise be done in along the road in question. His neighbor came over, said, "What's going on? What's going on here?" Started asking questions, and the next thing you know, that commissioner was questioned as to why did you declare a conflict of interest and not participate in the decision to hire the contractor because you were going to get a benefit or avoid a financial detriment of the way the road was repaired in a way that was favorable, more expensive for him. So that's just kind of the classic example. And what you see is all these rules, they intersect. He's obtaining financial gain or avoiding financial detriment. He's on a board, there's a vote, there's a conflict of interest, doesn't follow the conflict of interest rules. We can really get in the weeds on the various exceptions and exemptions for use of office. The most common ones that I hear about are ones that apply more to administrators, and that is, okay, well, there's part of a contract or compensation, that's not a violation. Honorariums come up. So if you are called upon as a board member to speak and somebody gives you something of $50 or less, you're able to accept it. For me, it's the like, oh, you shouldn't have. If that's the standard that we have. If it was like, I'm expecting for this, something to compensate me for my time, that's not an honorarium and just a traditional, gift if it's given. Also, separate rule is if your profession is one where you would get an honorarium for speaking at a conference, for that profession, you don't have to not participate, but it should be something that you can really clearly distinguish from your role as a board member. Reimbursement of expenses, and the complicated one is the gifts, which we'll speak about briefly. Common issues that have come up, benefits that go to the person. The Oregon Ethics Commission has said that these are you're not entitled to like frequent flyer miles that you get when you're flying on district business. I know. Volume.
Is that what the rule is?
That is an interpretation
That
of
is
the rule by the
outrageous.
Oregon Ethics Commission.
I'm definitely getting all the miles I can get my hands on.
Volume discounts. So this is something where it's only available to someone because they're part of a public body, either as an employee or in an elected position. We talked about compensation. The flip side of volume, which I should probably move this up right underneath it, is if it is on the same terms and conditions as the private sector, then that's something that's permissible. So if someone says you can get, Xfinity says you can get X cable deal because you are employed by or volunteer for Portland Public School District. But you can also get that if you're a member of the Oregon State Bar, and it's also offered to a realtors association. Then it's all right. And staff, you would want to make sure kind of documents the breadth of that type of benefit being available. There's the $50 in a calendar year. May not accept more than that from someone with a legislative or administrative interest in a decision that you would, for most of you, it's vote on. For staff, it's that they would make. That can also apply to someone who has like strong recommending authority. So if something's effectively delegated, but both the individual to whom the delegation is made, but also the supervising individual subject to that gift limit. A lot of exceptions here. Your relative can give you a gift. They had to make an adjustment 12 years ago because it was being interpreted to not allow your relative to give you a gift. Subscriptions related to performance of duties. There are 3 different exceptions to the gift rule that apply where you're acting in your official duties. Briefly, they are: 1, like a community civic event where you're in your official capacity. You go to these, we've got members of X Commission, we've got members of the Portland School Board. Can you stand up and be recognized? So that's one. There are some with reporting requirements where if you're asked to like go on a fact-finding mission or participate in a representative capacity to something that's much more expensive with reporting requirements and certain approvals, then you can go. And if you're thinking about doing some sort of trip in a representative capacity, I think you're going to want to make sure you're lining up and dotting the i's and crossing the t's.
I'm thinking about the trips to Finland to look at school design. Is it Finland?
Oh, what's
Yeah.
that?
Yeah, so that'd be an example, right?
Yeah, that would be an example.
An example of.
An example of a fact-finding trip that
Yep.
required documentation and reporting and. it was
And
really
you
extensive.
want to dot your i's and cross your t's on those because obviously they will naturally get
Nobody
attention.
ever sent me to Finland.
Uh,
I never got an offer to go to Finland. I would have taken that trip.
I think just, one, I just don't, I mean, you've gone through a lot of the exceptions, but I mean, Oregon's pretty strict on this. So
Yes, it
if
is.
you're friends with a principal and you've been friends for a very long time, but the person's not a family member,
Okay.
and you go out to dinner and that person buys you dinner and it's more than $50, you violated the law, right?
I doubt that they have an administrative or legislative interest,
In the school district.
particularly in it, unless there's something particular that's coming up. This is a long time friendship. You're looking quizzically.
Okay, because that's very different. Again, I work for government outside of this too, but the interpretations have been almost everyone has a
So
legislative.
let me make sure I understand the hypothetical. Who's taking who out?
The principal is taking the board member out.
Principal taking the board member out. For some reason, I heard teacher, and maybe there's no real difference. Who's
I
a
mean,
longtime friend?
Given that we vote on their jobs
You
and
do vote on
pay,
their jobs.
Staff
Yeah.
and budget.
Staff.
I think in that example, I'm not sure I go so far as there's always a legislative or administrative interest in all the relationships in this district, but as board members, it's a really, really big category.
Well, and again, I'll say, and I know there is a gray area. I mean, interpretations, City of Portland Metro is that any legislative or administrative interest that really could even happen. So for instance, let me use a different example, a community member who's advocating against changes in Southeast schools that we're making, who you might have been friends with for 20 years, who takes you out to dinner and it's more than $50, you probably
Yeah.
violated.
It's coming up, it's present, it's current. Yeah, I guess I was hearing more of a disconnect and generalization that I think maybe you could come up with a situation where it doesn't hit it, but you're right to be conservative. You know, Director Bailey used to be here and then we had the specific example. Is that?
Yeah, Scott,
Yeah.
his wife was.
Yeah, and his wife, you know, that was easier and crystal clear, but err on the side of,
I'm kind of curious about who's all getting all these meals.
yeah.
You're in good standing if you pay for your own, or you split it, or you pay the bill.
Since I began practicing, fortunately, it's become a lot easier where people just don't take any chances or risks.
Yeah.
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 Are these things different since I'm a non-voting member of the board? Like, do all of these things still apply to me? Like,
That's good.
as someone who doesn't necessarily make the decisions, but still sits on?
So that's a great question, and I don't know, but we'll figure it out because you still have the potential to influence a decision, and so that may bring you within the umbrella, and it can apply to all sorts of volunteers.
And I guess I'll add to the list if we're looking into it. For the district student council, which is the group that I run, I don't know if this would apply to them because I guess potentially through me, they inform my decisions and perspectives that I bring to the board. So potentially they might need to know that like, hey, your text could be looked at or something like that. Like,
Yeah.
I think also since we're a group of students, lots of times we operate in a much less professional manner than we do on the board. So I would definitely love to know that like if these are things that will apply to that group of students and to myself, that I definitely need to tighten the reins a little bit on our methods of
That's a great question, and it hasn't come up before, so thanks for raising it. It comes up in colleges and universities more often because the way they structure their governments and advisory bodies can be very different, but I'd be surprised if they're structured the same way here. So we'll figure it out. That will be a fun project. Thank you.
Just to clarify on Andrew's example, if the meal was less than $50 and it was just once a year, you could accept it.
That is correct.
You just can't like do 3 $25 meals.
That's right. It's accumulated over a year. Wait,
I mean, I know that You know how many cups of coffee you can fit into that
Food.
$50 section?
Food carts. Are-
Fewer than you could a couple of years ago.
Yeah.
Yeah.
They could use an inflation adjustment.
Yeah, since,
Let's see, entertainment. That's where it's not the main purpose. So I had to look up what's coming to Moda Center. Michael Bublé, you can't like go do a little ceremonial thing and then just go to Michael Bublé.
laser
Great.
beams,
Uh,
anything like that.
There are a lot. I mean, this is the challenge of, an hour. There are books on it. This notebook is hardly anything, but it's just a bunch of the resources there.
But just to clarify, Mike, on the entertainment, it's not $50, it's none, it's my understanding. The $50.
That's right.
Is food or drink, but you couldn't accept like, hey, this timber ticket is $30, because.
You could have a
Entertainment's
gift
not
that
allowed.
is a $30. That'll still be within the gift.
I thought entertainment was never allowed.
Oh, gosh. You know what's happened is I've gone too fast. Need to check again.
Yeah, because it was like,
Let me
that
check.
was like the big prohibition, it's like you can have.
Nobody's giving me
A
any tickets.
gift lower than $50. Yeah,
I want to make sure we get
I will confirm. That's what I got anxious here. As
I want to know where.
I want to make sure we get down to our meeting. Did you have one slide?
Because I'm not getting any of this.
I did, and conflicts of interest, we've covered before, and then, basically, if you have an actual conflict where, like the road commission guy, you cannot vote, you have to recuse yourself. If you have a potential conflict where you may have a benefit, you need to, declare it, and a lot of people just choose not to participate, or not to vote at all. You can vote, but you can't participate, which is a bit ironic. So you can't be in the discussion. So apologize for the rush there at the end, and I know you need to go, and I've got a couple things that I will be clarifying and looking up. Those are great questions, so thank you.
Thank you.
Yeah,
Thank you.
Randy.
We're going to start in 5 minutes, so.
We still don't have any Wi-Fi.
Nice.
Building?
I don't know.
I don't have
Up here.
Just got, we're having some issues, so it might be a little bit. That's what I'm saying.
Okay.
It's like it was like the lease acquisition,
We're
like if
getting
I'm.
tickets, we're
applying for
getting
scholarships, I'm not
dinners,
necessarily
we're getting-
I hope that's not what you're coming
I'm not getting anything. This is, I've been robbed.
Didn't you go to Denver? Aren't there some Denver?
Like that.
We went to Denver.
How was that? You got to report out on that.
Went to Denver. It was at that was the school board partners.
You report out on it.
meeting. It was fantastic.
I want to hear about it, but also we're supposed to report out on that stuff in our meetings.
Yeah, it was just a good meeting.
Yeah, good. You learned a lot?
Okay.
I learned a whole lot.
That's awesome.
They wanted us to, they were offering these financial courses
You mean like around budgeting?
around like, yeah, but it was intense. And so
Because they'd rather tell you in
this is for
advance.
Good, thank you.
Now it's giving me.
Also,
So-
because I'm definitely like, especially if.
Hey, right after the thing.
Click.
Right after the right after the thing.
I can also check with,
Thank you for my
Oh, great.
how was Mount St. Helens? But yeah, it's that.
It was great.
I
I haven't been there in a long time. so-
know we haven't been, we went 8 years ago. It just popped up on my Facebook memories.
Oh, really? It was a
Um,
glorious day.
We're thinking about going for a hike there over Labor Day, but we'll see.
Third party.
Hey.
It was so